Okay. Well, good morning to everyone. We appreciate your attendance today at our 6th annual Illinois Construction Legal Power Seminar. You just had the opportunity to hear from Matt Horn, who is one of my partners at the firm and is the co-chair of our construction practice group along with me. I'd like to say I taught him everything he knows, but that wouldn't be close to being true. He is just a fantastic attorney in the arena of the areas that you just heard him talk about. I don't know if Matt mentioned it, but he came from a background of construction. He's from a construction family, and you can kind of see that, and you can hear that in what he talks about and how he talks about some of these issues. This is not all academic to him. He's actually lived it for most of his life. You know, the other thing that I wanted to mention is what's really cool about this setup, and you can't see it when you're on the webinar, is that we're in a kind of an arena type setup in a classroom, and we have cardboard cutouts of each one of you that are attending right now, kind of like they do in the sporting events. And it kind of gives us this feeling of being with people again. And I can see a few of them here, and I think you're on this webinar right now. I can see a Scott Skiffstad from Lockton, and he looks like he's holding a plane ticket and a lacrosse stick. I'm not sure what that's all about. And then we've got right in the middle, Dot Clark from Henkels & McCoy. And Dot, you're leaning a little bit to the side. It looks like someone's handing you another lawsuit that you have to handle. I don't think that's anything new to you. And lastly, back in the corner, I see Tom Platt with Metra. And Tom, you seem to be looking down at your cell phone wondering when's the next time that Sue Ann is going to text you and she's going to want to set an emergency meeting. So it's really kind of cool. I feel like you're right here with me. My topic is legal developments and litigation for 2021. And I guess the one we have to start out with, it just kind of landed in our lap at the end of the legislative session in the Illinois General Assembly. And I believe this legislation is still sitting on Governor Pritzker's desk. Not yet signed, not yet vetoed, but it's probably the most significant thing that we can talk about today as it relates to litigation in Illinois, and it's a prejudgment interest statute. I'm sure many of you have heard of it if you're tied into litigation, and if you haven't, we'll talk about it a little bit right now. As I said, it's pending before Governor Pritzker. What it does is it amends the Illinois Code of Civil Procedure to add a prejudgment interest component to injury or wrongful death claims. I will say a little political statement from me. I believe it was a gift to the plaintiff bar from outgoing Mike Madigan. It is potentially a significant piece of legislation. Historically in Illinois, if an injured party obtained a judgment at trial for injury or wrongful death, there was a 9% post-judgment interest applied to the payment of the judgment. So if there was $1 million judgment and it took a year for it to be paid because of post-trial motions or appeals or whatever, then what ultimately would need to be paid would be $1,090,000. And that's been the law in Illinois and in most states, many states for years. Hold on. There we go. Prejudgment interest now has been added and is proposed in this piece of legislation. It's adding a section C. It actually was tacked on to legislation dealing with mortgage foreclosures and then ended up in the judgment interest section of the Code of Civil Procedure. As I said, it applies to personal injury and wrongful death. And here is the significant component to this, is it accrues from the date that a defendant has notice of an injury or death, either because of the occurrence of the incident itself or otherwise receives some written notice. In most cases, in the catastrophic and wrongful death type litigation that our firm's involved in, our clients will know of it from the occurrence of the event. Interest starts to accrue per this statute. It's a very simply worded statute that interest will accrue from 9% per year, per annum, from the date of an occurrence until there is a judgment by trial. By the way, if you settle a case before trial, technically the 9% per annum interest, prejudgment interest, doesn't apply, but as we'll talk about here in a second, it's going to become part of your metric if you are involved in claims on any level, that you're going to have to evaluate what that cost or that percent interest would have been if you went to trial. So it doesn't apply to cases against public entities, and importantly, if it's signed by Governor Pritzker, it will apply to pending cases from the date of the enactment of the law or when it's signed by Governor Pritzker. What are some of the impact and the practical considerations? I think on one level, if you're involved in claims or litigation or assessment of exposure on injury or death claims, you're going to have to reevaluate what the potential exposure is on all of your claims and cases. There's an issue of what constitutes notice of an injury. For example, not for this crowd necessarily, but we in the firm have a healthcare group that deals with a lot of medical malpractice, other related type claims. What do you do with a birth injury case or an injury to a minor who might be 5 years old when they're injured and has until they're 18 years old, actually 2 years after they're 18 years old, to file a claim? And then the case proceeds from there. You have 13 years of prejudgment interest on some unknown number that might be recovered at trial at some point. You know, I note that there's a statute of limitations, which is 2 years, so you could have an incident take place and 2 years could pass before suit is filed. In the construction arena, the statute of limitation in Illinois is 4 years. So you've got 3+ years that typically does pass while an injured party is either recovering or seeking workers' compensation benefits before a third-party claim is filed against other contractors or other entities on a site. And keep in mind, again, that if you have a case or an injury that's fairly significant that could be worth $1 million in a third-party claim, if the injury takes place 3 years past before suit is filed in a construction case, and then the lawsuit pens for 1, 2, or 3 more years, you might have 6 years between the date of incident notice and a judgment at trial. And in $1 million claim at $90,000 per year, that's $540,000 more on the exposure for purposes of the prejudgment interest. The rationale provided by the Illinois General Assembly, as promoted by the Illinois Trial Lawyers Association, was that this will motivate defendants and insurance carriers to settle meritorious claims in a more effective and efficient manner. You know, that might be the case. I've done this for over 35 years. I work with a lot of clients in litigation. I've been a trial lawyer my whole life. I've tried significant injury and death cases my whole career. And I have found that most clients and carriers that I work with are very, very in tune to trying to assess and evaluate and resolve those cases that should be resolved in a timely manner. I don't see this statute doing anything in that regard other than creating more potential exposure in significant cases. In fact, the Illinois Association of Defense Trial Counsel, the IDC, of which I am a member, and I was the former chair of the construction practice group of the Illinois Defense Council, and other industry associations that some of you are probably aware of, have communicated with the governor's office in objection to this, suggesting a veto to this legislation, and raising a number of issues that you can probably think of on your own. But there's a similar motivation. There is as much of a motivation potentially for a plaintiff or an injured party to delay the claim for purposes of an additional how much more in recovery at 9% than to push the claim to resolution. What do you do right now if this law is passed in Cook County, where there are no trials, likely for all of 2021? And in many of the counties in Illinois, throughout the state, because of COVID. Is this really the move to make at a time that will put this additional burden potentially on construction companies and other companies in Illinois and insurance carriers? But more and more companies today, as you know, carry self-insured retentions or other deductibles, and that puts the exposure directly on the companies. Is this really the time to do this in light of where we sit in the state of Illinois and across the country relative to what's happening with COVID and the impact that it's having on businesses? So that's a significant piece of legislation currently sitting on the governor's desk. It's probably the most important legal development for 2021 that's occurred. It just happened in the last week. We will keep our eyes on this. Our firm, as many of you know, sends out alerts and notices from our various practice groups that are involved with your businesses. We will do that as soon as we learn what is happening with this legislation. And of course, if we have pending litigation with any of our clients where we're representing you and or your insureds or your clients directly, we will have to have an evaluation and analysis of what it does to the pending claims that we're currently handling. Kind of a related issue, just looking ahead to 2021, is legislative COVID-19 protections. There's been talk of this at the federal level. There have been several states. You know what? Let me go back for 1 second just to identify, put the prejudgment interest statute in perspective. There are 23 states in the United States right now that have prejudgment interest statutes for injury actions. You can contractually agree to it. There's a 5% prejudgment interest in the statutes for other commercial claims. But for injury actions, there are 23 across the country. From our research, relatively quickly put together, none of them as broad-based as what is being proposed in Illinois. And I guess my last closing political comment will be, what a way to motivate more companies to either leave or not want to do business in this state, which is unfortunate. Legislative COVID-19 protections, no discussion of this in Illinois, but from the standpoint of keeping an eye out as to where legislation may be headed if it is discussed and what we're seeing from different states around the country, Florida is a good example, and that's what this slide relates to, as to what we're seeing as we keep an eye on what's happening in other states, because we have a number of clients obviously based in Illinois and elsewhere that do business outside of the state of Illinois. And what we're seeing, what the slide tells you, is we're not seeing an across-the-board immunity to litigation or to exposure for damages on COVID-19 third-party claims. What we are seeing is what's identified on the slide is some liability protections for a number of businesses, including what are listed on the slide, and procedures similar to what Florida is trying to enact, which is that there has to be some heightened level of scrutiny before a third-party COVID claim is allowed to proceed. This is not workers' comp, by the way. Let's be clear. This is third-party claims. For example, it was Kmart or Walmart, I think, was the case that we talked about in an earlier seminar in Illinois, one of the first filed, where a coworker claimed that their family member got sick because there was a policy at Kmart that didn't prevent, or Walmart, didn't prevent their employees from being in close proximity to customers, third-party customers who may have passed COVID to them. That was not a work comp claim. There was a third-party claim for wrongful death because a relative of the employee had died. In order to try to stem the tide of that runaway litigation, the states like Florida are requiring some heightened level of scrutiny, which is a physician affidavit that must be filed with the cause of action. You must demonstrate good faith effort to comply with authoritative government guidance, and that's a defense. If you comply with CDC and other state and authoritative guidelines, that may result in an immunity. It requires a higher level of evidence to prevail, but as you can see, it still allows for causes of actions to proceed. It does not bar them completely. I want to shift gears for a little bit here after talking about what was probably the most important item we could have addressed today, which was the prejudgment interest potential. What we typically do in this section of this seminar is we review some of the case law that has been decided in the state of Illinois on issues related to the more popular claims or cases that we see come across our desk. And we do a lot of, along with what Matt Horn was talking about and other commercial litigation in OSHA and workers' comp, we do quite a bit of injury and significant injury defense work, and particularly in the construction arena. And as I said, I personally have been doing that for a long, long time, trying jury trials with this type of issue in the case. So what we see in construction injury claims is two theories that are typically asserted. They're both grounded in negligence, but when an injured worker on a job site typically files a lawsuit in Illinois, it's based upon, in many cases, Section 414 and Section 343 of the Restatement of Torts. Section 343 is a premises liability statement. Generally, it's not applicable to construction in particular, but it has been adopted and utilized successfully in Illinois in order to attempt to hold an owner or a general contractor or an upper tier contractor who's allegedly in control of property and failed to keep it under reasonably safe for the worker as a cause of action to pursue. That we've been fairly successful in defeating that with motions for summary judgment. If it's anyone but the owner, if it's any of the lower tier contractors. But there have been some cases that have proceeded past summary judgment and to trial on that. And then the second theory is Section 414, which if you do any construction litigation or claim work at all in the injury arena, you're familiar with it in Illinois. It holds essentially that if an upper tier contractor exercises sufficient control over a lower tier contractor and the work of the injured employee, then even though the upper tier contractor, the general, and it's a subcontractor's employee that's injured, even though the upper tier contractor, being the general contractor, does not employ that employee, they may be liable for injuries sustained by the employee by virtue of the level of control exercised over the work and the safety of the work. And I want to make a couple of comments about that. And again, I understand that there is a differing level of experience relative to litigation in general in this group, because we try to cover all the bases related to construction law in this morning seminar every year. But there are many of you I know that are involved in injury claims and fairly significant claims. I have heard it said by a number of clients who come to us to represent them in injury cases on construction sites that if you represent the general contractor, you're essentially dead in the water. That if you're the general contractor, but what I hear is, well, you know how it is. The general contractor or the upper tier contractor who hired a tier 2 sub is going to be responsible because they took on contractual responsibility for safety on the job site, and there's no way to get around it. And I would tell you that that's just not true anymore. That used to be the case another lifetime ago under the Structural Work Act, and then kind of the lingering memory of the Structural Work Act for many, many, many years. And I'm old enough to have been practicing back when there was the Structural Work Act, and it was true. You really had no defenses at that point to the liability issues in an injury claim. You were just arguing how much the case is worth. Under Section 414, although this section imposes liability for upper tier contractors who control the work, the level of control based on what the appellate cases are saying over the last 10 years has finally started to be ruled in a way that's consistent with what the reality is on a job site. And what I mean by that is that let's talk about a general contractor who is sued for injuries to a subcontractor's employee. The fact that a general contractor has a job site safety program, has a job site safety superintendent, has a constant presence on the site, walks the site, evaluates safety violations on the site, that used to be a recipe for liability if there was an injury resulting from work on the site. It's not even close to that anymore. If what the courts are finally understanding, for years of us trying to make them understand it, frankly, in particular in Cook County, although we try cases all over the state of Illinois, is that if by contract, by supervisory responsibility or operational responsibility, the responsibility for the safety of the injured employee is delegated down to the level where it should rest with typically the employer, because that employer or subcontractor or a specialty contractor is typically in the best position to prevent the injury or accident, is typically most highly trained in the specifics or the particulars of the work involved, and the upper tier contractor is not. So there used to be the mindset that if you had I had clients ask me, upper tier contractors, general contractors, ask me at times back 10 years ago, if I see somebody violating one of our safety rules, should I just ignore it so that we're not liable later if he's injured? And of course, that's exactly the opposite of what should be happening, but that's what appellate opinions in Illinois were doing to the mindset of our clients back then. That has shifted. You can obtain the appropriate dismissal from a case if you're an upper tier contractor in Illinois, even under Section 414, even when allegations of a site-wide or a site-specific safety program are in place, if it's appropriate, if it's the appropriate outcome. If the upper tier contractor or the general contractor were actively involved in the operations of the subcontractor, were directing and instructing the subcontractor's means, method, and manner is what we talk about. If they were more than just a global oversight on safety, well, then there may be issues about whether there is some exposure or liability on the part of the general contractor for the injury. But in the typical case, not. So the point I wanted to raise there is that what we saw in 2020 and looking into 2021 in this type of case law, the trend is staying where it's been now for a while, which is to apportion responsibility where it should be apportioned for injuries, if any. Frequently, it's just the worker's mistake, and that's a workers' comp case. But if there is third-party liability on the part of someone, we are seeing that the cases staying consistent with apportioning that liability appropriately. Let me just highlight a couple cases that we have in the materials. Frieden versus Bott was a case in 2020. This actually had been a contested issue in Illinois. The short statement of this case is if you have an unpaid volunteer helping you do work on a construction project, this case involved roofing on a home, and that person is injured, say falls off the roof or is injured, and sues you for failing to provide them additional or adequate fall protection or safety protection, there's no duty on your part, the homeowner who asked your neighbor or your friend to help you work on a project, because there's not the economic connection there through contract or payment or otherwise, and the volunteer is free to walk away if they determine that they're working in an unsafe condition. Not a very common situation in Illinois, but an indication that the courts are starting to understand what the law should provide for and not provide for as it relates to liability in these cases. That's Frieden versus Bott. Ozig versus B Quality. This is an independent contractor, roof shingler, fell from a roof after it was raining, sued the roofer who hired him. An example of a case where the roofer who hired an independent contractor shingler, separate company, separate entity, and then delegated the shingling to that entity, did not control, did not supervise, just let them do their work. Another good example, summary judgment was granted in favor of the roofer for the injury to the independent contractor because there was not adequate control over the work, going through many of the details that we talked about, or I talked about earlier. That's a November 2020, very recent case out of the first district, by the way, which is Cook County. Jeffords versus BP, I wanted to mention this case. This is a federal case, so it's an Indiana case, but summary judgment in favor of a number of parties in a construction injury case at the BP plant, I think is where this work was taking place. But the last bullet point is the key, consistent with what I was saying earlier. Indiana and other regional states who are around us are starting to look at these issues the same way as Illinois. This case focused on the fact that there was no contract between the upper tier contractors and owner who were dismissed and the entity that employed the injured party. I only note that because that's a nice trend in Illinois. As I said earlier, the three levels, the three considerations for imposing a duty on an upper tier contractor are the contract, operational control, or supervisory control. The contract is paramount. That didn't always used to be the case for many, many years, but that's the trend, and that makes sense because that's the document that the parties try to utilize to define their duties and their responsibilities and their liabilities. So Indiana is consistent with where Illinois is going. I have a few quick cases related to insured and insurer conflicts of interest and choice of counsel. I thought they were of interest that were decided this year. As you all know, the general rule is an insurer in a case where there's an injury and the defense is tendered to an insurer, has the right to retain counsel and be involved in formulating some of the defense strategies, etc. And most of you are aware of, if you're involved in this area at all, that there are a number of ways that the insured can claim a conflict of interest as it relates to the insurer and potentially identify that it wants to select its own counsel, Cumis counsel or otherwise, Cumis, C-U-M-I-S, out of California, and have its own counsel direct the defense of the case. That's the general rule that's just stated on this slide. There was a case out of the Northern District this year in September that was interesting on this issue. If you are facing this issue on any level or have any questions about it, that it was a construction defect claim. As any of you know that handle these claims, there are a number of reservations of right that can be asserted. One of them is it was injury or damage to your own work, and therefore there is no third-party liability insurance available to the contractor who was alleged to have performed defective work but only caused damage to its own work. It's the own work exclusion. What the court here said was, simply put, middle of the paragraph, that the pleadings were detailed enough that the claim that there could be a conflict with Westfield's counsel trying to direct the discovery to the own work exclusion versus damage to a third party's work was without merit, based solely on the detailed pleadings in the case, which is interesting. And if you do any insurance coverage work or have been involved in that at any level, the four corners of the pleadings and sometimes the eight corners of the pleadings in the insurance policy are what determine the duty to defend at the outset. And this was an interesting decision. I have a couple of other, as I run up against my time, that are included in the slide deck that you have. I won't go into those right now. They talk about similar issues and a final miscellaneous case related to compliance with specifications on a job site and whether that creates a question of fact or not, which I thought was of interest in Illinois this year. But you can read it. I think the bullet point is sufficient enough to at least give you an idea of what these cases deal with. And if you have any questions, you can reach out to us. I can further discuss them or explain them. I know that I ran up against the time. I don't know if, let me look real quickly. Double click. So I'm looking at the OSHA questions, Emily. Oh, here we go. I do have a couple. Just real quickly. Yeah. So good question on the prejudgment interest, which we can end on this because it puts a finer point. Is if a case occurred back in 2018, but due to no fault of the allegedly liable party, the injured employee delayed, and then there were COVID-19 delays, and the case doesn't settle, and you can't get back into court because court's suspended. If Pritzker signs the legislation, are you liable for interest back to 2018? And the answer is no. For pending claim, actually, good question though. If the case had been pending, the answer is no, because for pending cases, it is effective from the date of signature. Unclear yet whether, this is a very good question, whether a claim that was pending and not yet asserted, but you had notice of it, is then filed after the legislation is signed. Does the interest date back to 2018? That's unanswered in this current legislation, and it's a very good question, and it's a reason why this area is going to be rife with additional litigation down the road. That's what we have. Thank you for your time. Appreciate it.